Next, I'd like to call to the podium Penelope Eden and Deanna McMaster from, I don't think there are stairs over there, are there? Yep, there are, who both travelled down from Brisbane. We are in, I would say weekly, but more often a couple of times a week, with Penelope and Deanna talking about the new Aged Care Act, the implications for workforce, the implications for operators because of the workforce, and the timeframes, i.e., if we have a new act on the when it's due, how are we going to implement that? And so that's what we're going to unpack today. Thank you.
Thanks so much for the introduction, Chris. We're delighted to join you today. I think this is my 5th or 6th year coming to Leaders Summit, and I really feel the sense of optimism in the room today, and it's an exciting time to be part of the sector. We're going to shift gears a bit. The lawyers bring in some of the regulatory settings for you today. We've been tasked with exploring the new Aged Care Act and specifically the implications for operators of retirement living and aged care. So we've got 25 minutes. I know we're already running over, so we'll try and focus on the key provisions that are, I think, most important for you today. So I'm going to do my whistle-stop tour, high-level overview of the new exposure draft. We're going to look at some of the more significant provisions. We've heard from many of our clients of what's concerning them most. So looking at the key differences between the two, the old and the new, the definition of high-quality care, the new statement of rights. Deanna and I are going to spend a bit of time unpacking the new statutory duties, which is where Deanna's expertise really comes in. As I try and navigate the slide deck. There we go. It's a bit of a running joke at my shop that I'm a better lawyer than I am IT technician. So you'll all be really well aware the last few years have been really transformative for the aged care sector and for the retirement living sector and those delivering services to older Australians. There's been a rapid transformation, particularly in terms of a step up to a whole suite of regulatory reforms over the last sort of 12 to 18 months. And these have really represented a clear step up, I think, in the obligations of providers, but also the expectations of consumers. And we've seen a real repositioning, we've heard it today, of the consumer at the centre. And we see this momentum really continuing in the drafting of the new legislation with consumers front and centre. It's a real step change, of course, from the existing legislation, which is focused on subsidies and provider obligations, to looking at consumer rights. So as a lawyer, an interesting observation from me when I opened the exposure draft was to note that it has a different constitutional basis from the existing legislation, which takes its power from the Corporations Law. So this legislation relies on the external affairs power, and I'm getting to my point of why that's interesting. That's interesting because it enables different operators to enter in the sector, a bit like what we've got in DIS. So it really enables the drafting to pull on things like the UN conventions, and you can see that in things like the statement of rights. Another characteristic, I think, that I've observed in the drafting is the focus on what I call relational regulation. So really incentivising providers to drive cultural change and improve outcomes by working in a more collaborative way with, key stakeholders, regulators, workers, older people and advocates. A bit sort of as we've seen modelled in the healthcare sector. So it's clear the new Act is very different to the existing legislation, and that slide that I've put up there just goes through some of the key, what I consider to be some of the key differences. So we've got, a single structure, one new Act and a set of rules that sit alongside the legislation. A single point of entry, new eligibility requirements, new system oversight and accountability arrangements, a new enforcement model, which we're going to dive into in a bit more detail shortly, and new funding arrangements. You'll no doubt have all seen the inclusion in Section 9 of retirement villages and the definition of residential care home. I had lots of calls when people picked up the exposure draft for the first time, and that did, I have to say, come as a bit of a surprise to all of us. There was initial concern, I think, that retirement villages delivering any kind of care services would be caught by the regulatory framework. And on closer reading, I've spent some time examining those provisions. There probably are several preconditions to that occurring. The first is that the accommodation will need to be fitted, furnished and staffed for the purposes of providing aged care services, and they must also be registered to do so. The second is the provider's got to be delivering a funded aged care service, and that will be specified in the list of services that will be published with the rules. So this will distinguish private services, for example, from the nexus here really being the delivery of Commonwealth-funded care services. So while the exposure draft has given us further clarity about the new system and how it's intended to operate, I'm sure like me you observed the many significant placeholders, lots of missing information, which is starting to take shape now, of course, with the recommendations of the task force, which Grant Corduroy has spoken to you about this morning. Obviously the key placeholders relating to financing and funding of the sector, information around the statutory duties and the compensation pathways. The other, I guess, tension point for our clients that we've been speaking to is the implementation timeline, so concerns about how providers will be supported to transition during this period. So there's a lot of moving parts that are slated to take place over the next, intermediate period, short-term and intermediate period. And we're going to focus, as I said, on the definition of high quality care, looking at the statement of rights and then diving into the statutory duties. So consistent with the Royal Commission's vision for an aged care system that aims higher and doesn't just focus on minimum standards, the new Act will seek to define high quality care, and this is intended to complement the statement of rights. The new Act introduces 3 limbs which identifies high quality care as the delivery of services which prioritises the individual, puts them first, upholds the rights of the individual as articulated in the Statement of Rights, and prioritises a range of holistic factors, which I've put up on the slide there. Factors like kindness and compassion, timeliness, privacy, connection to community, inclusivity, all the things that we ourselves would want if we were a recipient of care. The definition focuses on the characteristics of care as opposed to specific outcomes. And so what this means, I think, is that it won't be absolute, something that you meet or you don't meet, but rather something that you're working towards over time, again, reflecting the relational regulation focus that I mentioned earlier. The exposure draft has confirmed that there won't be a duty to provide high quality care, as recommended by the Royal Commission. However, there will be certain registration categories, so registrants will be required to demonstrate their capability for and commitment to continuous improvement. I'm just going to whip through this slide quickly, statements of rights and principles. So the Statement of Rights sets out what people accessing the system should expect, and it's drawn from the wording proposed by the Royal Commission, as well as the Charter of Rights. So while there's no individual right of access to funded aged care services, some of the rights proposed to be included are things like a right to services being delivered by workers with appropriate qualifications, skills and expertise, a right to culturally safe, appropriate and trauma-informed care and services, and a right to access palliative care and end-of-life care services that may be delivered outside of the aged care system as well. The Statement of Principles will work complementary to these rights and will guide the decisions, actions and behaviours of those responsible for operating the aged care system, such as providers, obviously, and the Department and the Commission. So the Statement of Principles aims to drive cultural change in pursuit of 4 key themes: the person-centred focus, valuing our workforce and our carers, transparency and sustainability, and continuous improvement. As I said at the outset, the key feature we're hearing from most of our clients that is of concern is the drafting of the new statutory duties, of which there are 2. So there's a statutory duty created by the exposure draft on registered providers, and there's a duty for responsible persons. So under the new Act, registered providers will have an overarching statutory duty to ensure, as far as reasonably practicable, that their conduct does not adversely affect the safety of individuals to whom they are delivering funded aged care services. And this language and drafting has come directly from the work health and safety legislation, which is Deanna's area of expertise. So I'm going to invite Deanna just to talk through these provisions.
Thank you, Penny, and hi everyone. It is really interesting to see the exposure draft going down the same path as the safety legislation, when it is still unclear after about 10 years in the safety context what reasonably practicable means and what due diligence means. Nonetheless, as Penny has said, there are some real insights we can take from the Safety Act in an aged care context and how these provisions might be applied. The exposure draft broadly mirrors the safety legislation's definition of reasonably practicable in the context of the registered provider duty, and interestingly adopts the same factors that must be considered except in relation to cost. The factors that you have to consider when you're weighing up risk begin with the likelihood of the adverse event occurring, then the degree of harm that might result from the adverse event. It's also relevant to consider what the person concerned knows or ought to have known about ways of eliminating or minimising the adverse event. And finally, the availability and suitability of ways to prevent the risk. Interestingly, to Penny and I, in discussions we've been having, that list doesn't include reference to the Statement of Rights. We think it probably should. Because the exposure draft, of course, also includes a requirement to consider the rights of individuals set out in that statement, which might suggest that the duties aren't actually absolute. For example, the ability of an older person to exercise choice and control, even where that choice involves personal risk, may be a weighing factor when examining reasonably practicable, and that's why I think it should go directly into the list. So a key challenge everyone in this room is going to face is exactly what is meant by what's reasonably practicable. And as we've mentioned, there's a reasonable amount of consideration of this in the safety context, although it's still not straightforward. Once you move beyond considering the likelihood of the risk and the degree of harm, which are easy to understand, we then need to move into the concept that's going to require registered providers to stay on top of what's going on in the industry in terms of the way an adverse event is being managed and be proactive about staying across developments. For example, to take a basic concept, moving and handling equipment of older persons, if there was a new wheelchair in the market that meant that it eliminated the risk of one of the employees' failures to apply a brake, and that technology was readily available but you weren't aware of it, you probably won't be exercising your duty in a reasonably practicable way. So it is going to require all of us to share knowledge in a really proactive and a deliberate way if these laws come in this form. In the safety context, we also know that this duty extends to ensuring that there's a safe work environment and equipment, including appropriate facilities, information, training and supervision. We think we're going to see that replicated in the aged care environment as well. So it's going to require all of you as registered providers to create safe and effective internal systems of care, underpinned by policies and procedures with appropriate training, oversight and monitoring. The new Act also establishes a separate duty for responsible persons to exercise due diligence to ensure that the registered provider complies with its statutory duty. Again, for any of you in executive and board roles, that sounds familiar because it replicates the Work Health and Safety Act duty. What is new, though, is the use of the term responsible person, being people who this duty attaches to, and this extends well beyond what the safety legislation does. The term responsible person here largely follows the current definition in the aged care space of key personnel. This means the statutory duty, this personal one, is going to attach to people who are responsible for making executive decisions and any other person who has authority, responsibility or significant influence over decision making, and those two categories are straightforward. But what is more concerning is the extension then of due diligence to the registered nurse responsible for the overall management of nursing services of a registered provider or at an approved residential care home, and any person responsible for day-to-day operations of the registered provider. Like the work health and safety regime, everyone in those categories can be personally liable for failing to exercise due diligence, even if the provider hasn't breached its duty or there's been an adverse event. However, the key is that the responsible person isn't going to be deemed to have committed an offence simply because the provider hasn't discharged its duty, and I think that's important. This really does replicate what the Work Health and Safety Act provides for, which requires there that you exercise due diligence to ensure that the operator complies with their duties. Like the safety legislation, this is limited by what are reasonable steps. So responsible persons, there is a limit to what you have to do. But the steps are positive and proactive. And we often talk about this requiring 3 elements: getting the right education, getting the right reporting, and then raising questions and closing those questions out as part of that duty. In terms of what will be reasonable is going to depend on the role and influence of the individual. And I think this is important for those 2 later categories of individuals, particularly the registered nurse, who is going to need to exercise a different level of due diligence to someone in a more senior executive or board role. Helpfully, the new Act does provide some guidance about what we mean on reasonably practicability in the context of due diligence. The first job that every responsible person needs to do is acquire and maintain up-to-date knowledge, which means staying across industry-specific issues like you've never done before and making sure you do regular training on what the duties are on the registered provider. It also requires responsible persons to actually understand operational hazards and risks. It's not a desktop role. It means consulting with people receiving care, your staff, and monitoring the way critical risks are managed and undertaking regular site visits. The next step is making sure that there are appropriate resources available that are used to manage the risks posed by adverse effects. This means things like quality IT systems for reporting critical risks, but also having adequate staffing levels to support responsible persons to discharge their duties. The next step is making sure that you have a system to respond to information about incidents and risks in a timely way. That means having really good sets of KPIs regularly reported to you, being familiar with adverse harm indicators, making sure auditing is occurring and that you see some of those audit outcomes being actioned and closed out. And the final job, as if it wasn't already enough, is to make sure that you establish, maintain and verify that there are compliance processes. That means understanding what processes are in place to meet the registered provider duty, as well as making sure that any actions are actively followed up and you have systems for doing that. While this list isn't exhaustive, our view is that this new Act is really only trying to capture the delivery of funded care to older people, as opposed to the broader safety considerations, which will remain under the safety frameworks. Many of you will be familiar with the due diligence report that you get in a safety context already as boards and executives. There may be a similar solution here in the aged care context if this duty comes in this form. Right now we're seeing regulators request those reports already and minutes documenting discussions of those reports, and we really think we'll see the same thing. I'm now going to hand back to Penny to talk about the offences for a breach of the duty.
Looks a bit like the one-pager that the department published. So I've tried to capture really succinctly on a page how we understand the way in which these provisions will work. So when we examine the scope of the statutory duty and whether an offence has occurred, there are essentially 3 key questions to consider. The first, did the conduct complained of fail to meet the relevant duty? Second, did the conduct amount to a serious failure? And third, did the conduct result in the risk of or actual death, serious injury and illness? So I'm going to break those down for you. The first precondition is that the provider or the responsible person has engaged in conduct that fails to comply with their duty. So the conduct may be a positive act or it might be an omission. Second, an offence will not be made out unless the conduct amounts to a serious failure by the provider or the responsible person. And the conduct will amount to a serious failure where it exposes an individual receiving funded care services to a risk of serious illness or injury and involves a significant failure or is part of a systemic pattern of conduct. Helpfully, the term serious injury or illness is defined, and it will include things like where the client requires transfer to hospital, where they have sustained an injury such as, a head injury, a burn, for example, or it might be specified in the rules. But to constitute a serious failure, the conduct must also involve either a significant failure or evidence of a systemic pattern of conduct. Hence why I've tried to put this succinctly on a page for you. So a significant failure involves conduct that represents a significant departure from the conduct that you could reasonably expect, having regard to the obligations on providers under the legislation. In terms of the definition of systemic pattern of conduct, that's also been defined, and it's probably what you would expect. So it involves an examination of the number of times the events occurred, the period over which the breaches have occurred, the number of people affected, and the provider's response to the risk. So once a serious failure to comply with the duty has been determined, an offence will have been made out regardless of whether the conduct results in actual death, serious injury or illness, which perhaps suggests, I think, that the Act intends to capture near misses. And Deanna and I were talking earlier and she said that's exactly the situation in the WHS regime. But where there's only been a risk of actual death, serious injury or illness, the registered provider will have committed a strict liability offence for a serious failure, and this carries with it penalty units, so a financial penalty. Where the incident results in death, serious illness or injury, the penalties are almost 3 times that. Where there is a finding of a fault-based offence, you'll all be aware, no doubt, of the current drafting, which makes it a criminal offence. And fault-based offences carry much greater financial penalties. You'll be aware that the criminal sanction provisions were not proposed by the Royal Commission, but were in fact part of an election commitment. And this is understandably a very concerning development for providers. I've got a few minutes left and I'm just going to quickly touch on compensation pathways. As I said earlier, this is still unclear. We've done the best we can on the current drafting. And the way in which we think this will work is in a similar way to what exists in the work health and safety regime and the workers' compensation regime. So the Commission will be empowered to seek an order from the Federal Court for compensation, either on their own behalf or on behalf of the care recipient. The application may also be made by the care recipient. It must be made within 6 years of the incident, so we see some changes here in relation to the statutory timelines. And as I said, it's an offence of a statutory duty, which does carry the 6-year time frame. I said earlier that it was an offence of strict liability, which again is confusing perhaps in the context of looking at steps that Deanna talked you through about what is reasonably practicable look like. If it's an offence of strict liability, the issue of fault becomes irrelevant. So there's some little technical issues that we've been unpacking with some of our clients to really understand how this is going to work in practice, and it still is not entirely clear to any of us. So Chris, I might just pause there. I know we're running very close to time and happy to take some questions. Thank you.
Do we have any questions? Scanning the room. Sally, one over here. Tiff? And whilst we're waiting for Sally, is there another? Sorry? Thank you.
Just a very quick question. I'm from a small provider in regional South Australia, and my board are very concerned, obviously, about this. One of the questions they've asked is, if they can't meet the care minute requirements, what liability does that expose all of us to under this statutory requirement?
Turned on? Yeah. And that's another question that we've been certainly fielding as well. Look, it's currently unclear. I guess what that speaks to is the obligations under the legislation, which either you can comply with or you can't. I guess in the context of an incident, an adverse event occurring and someone suffering harm, it would be those features that would be taken into consideration in determining whether an offence had occurred. So then it becomes important, I think, to look at what steps you're taking. And I appreciate in regional settings, workforce is their number one challenge. I hear that, absolutely, and acknowledge that. So I think, Deanna touched on the risk assessment tool, so documenting the steps that have been taken to attempt to obtain workforce. And it will always be, I think, an issue that will be something we will need to keep across in terms of whether the workforce is appropriately skilled to respond to changing acuity of clients that you're delivering services to, where you've got workforce shortages, of course, as well. So documenting that through a risk assessment tool would be probably the number one piece of advice that we would give you, I think. Yeah.
Sally?
Hi, Penny. I'm just interested in your thoughts about the introduction of retirement village into the definitions. And we have very strong concerns about the separation between care and accommodation, as I know many of us do, and we put in a submission last week on that exact topic. So yeah, just would like to hear your thoughts about that.
Yeah, thank you. It was a shock, actually. It was Chris Baines' article that triggered me, and I thought, gosh, that's I didn't see that coming. So Chris, you were on the ball with identifying and calling out the fact that retirement villages had been included in the definition. When I stepped through, it's certainly been a question that many clients have been very concerned about. An interesting observation, I think someone earlier, maybe it was you, Chris, said, for the first time we were being recognised in terms of our role in delivering care services. I think from the other flip side to that is the concern that we're now being captured by a regulatory regime which has some fairly serious penalty provisions attached to it. And as I said earlier, my view is that the nexus is the delivery of funded care services. So where you've got a hybrid model and you're delivering private fee-for-service care, for example, as opposed to care under a home care package, I think that still falls outside, as it does currently. But there is a challenge, of course, when you're delivering a service that provides both components of care in its model. To then explain to the regulator which parts of the service they can regulate. So I think that's where the blurring of the lines, which was what I spoke about last year, I think, where that comes into play. And it's, we heard Cam Ansell's presentation just before ours about these really fabulous, innovative models of care, which I just, like Cam, feel so excited about the opportunities for the sector, and not just for us as operators, but for our clients who we are delivering these services, about those opportunities. And certainly this is a regulatory burden that we need to navigate. And I think that there is a way, but I think that uncoupling of care and accommodation is perhaps where we're heading toward. Oh, we've got the music, have we? Oh, no. Sorry. I thought I was getting the wind-up music for like the Oscars. Time to go.
Yeah, sure.
One last question, Victoria.
One last question. Hi, thank you. So my question is just around, as we talked this morning, we're facing workforce shortages. What is your what are the sort of offences and compensation that might be faced for aged care workers who fall on the wrong side of the Act, including volunteers, as I understand as well?
Yeah, so it's certainly, in terms of the statutory duty, there's a new, as Deanna talked through, there's a section 121 duty for responsible persons, and obviously that's new for us in terms of nursing staff who are in charge of a facility having a positive statutory duty placed upon them. And I think that's certainly cause for concern. I think there's perhaps unintended consequences around how that might operate. So I do share that concern. In terms of workforce shortages, again, I think, as we sort of discussed earlier, Victoria, I think that it's an issue that is not going to go away quickly. It's something we continue to grapple with. And I think that in terms of discharging, in terms of what evidence you would need to discharge the duty, if you were running, for example, under care minute requirements or just short-staffed, what steps you've taken, what reasonably practicable steps you might have taken to attempt to get the workforce, and what other steps you might have had to implement as well. I don't know if you have anything to add.
I think it's not even just this legislative regime, it is the way the safety regulator looks at this as well, and something we've been grappling with in the context of occupational violence, which of course we experience in aged care from time to time, is the safety regulator has a view that reasonably practicable means if you do not have adequate staff to provide the service safely, you need to find other safe ways of delivering that service, which is very difficult to navigate when we're facing such serious workforce shortages. But that's why just getting those risk assessments documented about the steps you've tried to implement to manage those risks, if you can't create extra bodies, is just so important.
Okay, thank you very much. Can we show our appreciation? Actually, before they actually leave the podium, one point I'd like to make, if I can, it's not a question, it's a commentary from me. In our conversations over the phone, where I'm usually going WTF, the word compensation, that figures so prominently there. What the discussion we had, Penny, was an aggrieved daughter who feels that her mother hasn't been treated in the appropriate fashion, says, I'm going to teach you a lesson, I'm going to take a case out against you, and I want compensation. How much are we going to have of that?
How much are we going to
have of that?
have of that? Look, I do, the cynic in me says that we will see an uptick. I think in claims for compensation for breach of the statutory duty. I think that it will level, but I do think, I mean, I'm already starting to see in the work, I've been working in this sector, actually it's probably too long to care to think about that, but we're seeing an uptick in nervous shock claims actually at the moment. That's the one where we're seeing a lot of not just out of COVID, but in relation to, substandard care, for example. So I do think that insurers are going to be looking closely at this sector. We've already seen carve-outs for abuse claims. I think it's going to be the next wave will be the statutory duty claims. And this is the thing, I think you and I have spoken about it, Chris, and Deanna and I have spent a lot of time thinking about this. How does that work? The ability to exercise due diligence and take reasonably practicable steps, how does that intersect with a strict liability offence? If you're not able to demonstrate those steps because it's an offence of strict liability, which means you don't need to establish fault, what is that going to mean in terms of that initial testing of the waters with these duties? So, we've never really seen a lot of civil claim action in aged care, and there are a whole lot of reasons for that. It's a bit different to what we have in the healthcare sector, but I do think we'll see an uptick until it settles, at least initially, and I don't know if that was your sense with the work health and safety legislation. Okay, so with that happy news, we'll go to lunch. I know. So if I can, thank you very much, ladies. Well done. So we're going to retire to lunch. If I can draw your attention to the two factors, please. Firstly is when you go downstairs, your plate will be in a position on a table, so please use that plate and eat it before you go to the buffet. The second thing is there's going to be a tent card on each table from AusMed, who's one of our platinum sponsors. And it's going to give you a chance to test your knowledge against your fellow delegates. On every table of the restaurant will be a tent card with a QR code displayed to answer a series of questions relating to the new strengthened aged care quality and standards. The leader scoreboard will be displayed at AusMed's exhibit in the afternoon at tea. Is your organisation prepared? This is actually a very good test. I've been through it. I failed, so you'll do better. So I expect that we'll be back here at 2:30, and it is for the breakouts, which means that this room will be divided into two. One side will be retirement living, the other side will be residential aged care, and the home care breakouts are going to be held in the exhibition area. So we'll see you back at 2:30. Thank you very much.